attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
You may be seated. All right. Good afternoon. Welcome to an oral argument session of the 5th District Court of Appeal. As previously introduced, I'm Rand Wallace. Joining me on this panel this afternoon is Judge Harvey J. To my right and your left, and to my left and your right is Judge John Harris. So we have one case on the docket, Tucker versus Tucker, and I'm going to assume, Mr. Grassley, that you want 5 minutes of rebuttal unless you tell me otherwise. And just make sure you've got any devices that make noise. We mute those. And other than that, you may proceed, Mr. Grassley, when you're ready.
May it please the court. Judge, I know Judge Jay's heard this from me before, but I wear hearing aids. If you see me playing with my cell phone, I am not posting on social media. I'm trying to adjust the tenor because every room's a little different.
No problem.
I'm sorry, Bill Grassley on behalf of the appellant, Adam Tucker, who is the father in this case. The issue we're here about has to do with the judge's disposition of time sharing, which is crucial because it's put my client in a no-win situation. And in order to explain that, first I need to do a housekeeping measure. Dr. Blackman was appointed to do an evaluation and some recommendations as to what should happen going forward. And I was working off of a paper copy of his actual report, which is in the record at 821 through 871. And when I was looking through earlier this morning to just flipping through the record to see a couple of things, I realized that it is completely blacked out. And when I saw redacted in the record, I thought, well, you know, they've taken a black pen and covered up some of the names or something. So with the court's permission, I'm going to make sure that that gets transmitted by the clerk of the circuit court in unredacted territory so the court has that. I think the starting point for the legal context for where we are, because I do want to talk about the facts if I can. Obviously, I'll answer whatever questions you have, but the real bottom line is the Judge Cole, excuse me, her understanding of the law said, and she made this very clear, page 2170 and 2171 of the supplemental record is a colloquy she had with Dr. Blackman, excuse me, about his recommendation that there be unsupervised time sharing and that they get into a graduated step up. Let's make sure that the factual context for this conversation is clear. The former wife, the appellee, files a petition a month later, and there's time sharing going on between the two of them voluntarily while this is happening. A month later, she files a separate petition, an amended petition, and files an emergency motion to have my client evaluated and have only supervised visitation. She admitted on the record that during the time that they were doing time sharing that she did not want to have to pass the child, exchange the child except at the family nurturing center because she didn't want to deal with the husband. She didn't want to have to talk to him or see him. And that is driving a lot of this, as I will get to if I get a chance.
Let me ask you about that, if I may, Mr. Grassley. The purported bad acts by your client, did those all predate this amended petition and the emergency motion?
Yes.
So I understand the record. They were time sharing.
Yes.
They were sharing the
50-50,
child
I
in
think.
person, correct?
Yes.
And then for things that predated that, she files the amended petition and the emergency motion.
Right. And she admitted in her testimony at the final hearing that there really wasn't an emergency. Nothing had happened between the first. She, I think, tried to blame her attorney for that. But regardless, I think the important issue here is the Supreme Court's decision in, I call it the initial case, CN versus IGC, which is discussed at length in the initial and reply brief. That case it was on a conflict to the Florida Supreme Court based on this court certifying the underlying case as in conflict with other districts. The first district aligned with this district, saying in a modification proceeding, the trial judge is not required to set, if he's reducing time sharing for one of the parents, does not have to specify concrete steps that parent must take to get back to the prior time sharing. And other district courts said, no, the judge has to give that parent some specific things that they have to do to get their time sharing back. And this court held, no, that's not true, that nothing in the statute says that a court has to do that. And the Supreme Court agreed with that. This court had also said the trial court's not even authorized to do that, but that issue was not addressed by the Supreme Court. And the reason I'm bringing up this case is because it is in the context of what the judge thought the law was, which it's not, because this is not a modification proceeding. The ramifications of this make modification case law important, but this is the initial time sharing and the initial parenting plan that's being issued. And so the question is, can a judge, a trial judge, authorize some type of step-up, reduced, supervised back to unsupervised time sharing in an initial parenting plan? And this judge explicitly said, no, I can't do that. The law won't let me do that. Because the only person that said, other than the wife, the appellee, that said that the supervised was the way it needed to be forever, essentially, was Judge Cole, our circuit judge. Dr. Blackman, Dr. Jackson, and my client's therapist all said that there needed to be a gradual reintroduction of unsupervised time sharing. The lady from the Family Nurturing Center testified that my client was always on time. He never had any issues. The child loves him and is bound with him. He asked for, and they had available multiple times where he could have additional supervised time sharing, and the wife refused. She blamed it on COVID, and she got the nurturing center to allow him to visit with his child only when there was no one else there, no other families. She didn't mind taking him to Target or grocery store, but when it came to supervised time sharing, she used that as an excuse to not give him any more. The judge, in the final judgment that's under review here, gave my client one period of 90 minutes per week for supervised time sharing. And procedurally, a couple things happened that are relevant just to understand how we got here. There was a final judgment entered that contained all of these findings. My client appealed. It was, the final judgment still had a component of child support to be dealt with, so it was dismissed because it was non-final. But before that happened, my client had filed a motion for rehearing, and the judge did a very detailed and defensive response to the motion for rehearing about why certain things were improperly stated, et cetera. But the important thing is the judge said that the rehearing motions claimed that this was a permanent deprivation of his rights to be a parent was not true, because if the judge said if he will just do what he's supposed to do, of course he can modify his time sharing. Well, that's the problem here. That's not what the case law says, and that's the ultimate dilemma, the catch-22 that my client finds himself in. And what we're asking for is that you recognize that the judge has the ability to introduce whatever may be appropriate in an initial parenting plan to increase the time sharing to where both parties have whatever the judge ultimately determines is warranted. But in this case, the judge has said, no unsupervised time sharing. You get to talk to your child every day at 5:30 on the phone or Facebook or whatever the media may be, and that's it. Absolutely no parental rights, no parental responsibility to my client. He gets to decide nothing. Theoretically, she's supposed to, talk to him about it, but he has no right to override anything. The judge here took it upon herself, despite what all of the expert testimony said, was that my client's problem was he had an alcohol dependency problem, and until he dealt with that, he was not going to ever have unsupervised time sharing. That's not what any of the experts said. Only the judge said that.
And the court's ruling about no alcohol, that was not tethered to the child, correct, Mr. Grassley?
That was not what?
It was not connected to the child.
It wasn't. You'd have to stretch really hard. And the appellant, I mean, the appellee has done this in the answer brief and said, well, of course the court was worried about the best interest of the child. Only Judge Cole decided that my client needs to abstain from alcohol. There was nothing from any of the other experts who testified that said, yes, he drinks and he's used that as a way to deal with his emotional problem, but his real problem, the fundamental problem my client has, which was admitted in the circuit court and is admitted here and in briefs, and I'm telling you now, he's had an anger issue. There was a lot of stuff that he never learned how to deal with emotionally. Stuff not being a good legal term, but he had a lot of issues. All of the therapists and Dr. Blackman, who did the evaluation, recognized that his main problem was anger management and learning. He specifically said that's a learned behavior and you can unlearn it. His therapist said the same thing, that he's never understood how to not explode. He's got that, certain people have hair triggers, and I'm not justifying it, but there was a couple of incidences where the child was a baby and he made loud noises and screamed and yelled. Okay, that's bad. I made my baby girl cry when she was little because I screamed at the Gators football playing on television when she was little, and she started crying, so I learned I can't do that anymore. I have to use a nice voice when I'm angry with my football team. All of the evidence said that he was coping and improving and learning much more his anger management skills. What happened here initially when the judge got the emergency motion to suspend time sharing, unsupervised time sharing, sent the parties to mediation. Parties came up with a plan where there was going to be unsupervised visitation by my client and how they were going to do it. This judge decided she wasn't going to approve that. Now, and this is a rhetorical question, what kind of judge doesn't let the parties at least have a shot at what they could agree on? And the answer is this judge. She decided that she knew better and that the father had an alcohol problem, and that was involved with his anger issues, and that until he stopped drinking, there wouldn't be any chance for modification. I mean, any chance for unsupervised visitation, and that gets us to the real dilemma. If this is allowed to stand, I need this court to explain why the case law, such as the Bell case and the Allen case, say you can sober up, you can do anything you want that makes you be better and just deal with the issues that were at issue in your case, but that's not enough to modify a time-sharing plan. You have an extraordinary burden, and it's not enough to just show that you've complied. So the way this final judgment legally has impacted my client is it has said, number one, you have to go into an AA program, which is nobody ever suggested that. The judge made this up. It is religious-based, and it's nothing against AA, but a judge can order therapy. A judge can say, I find you have an alcohol problem and you need to address it, and whether that's borne out by the facts is a separate issue, but to say you have to go to this program and you have to use a new counselor who has a master's or better, and not somebody that you already have a relationship with or who's involved in the litigation, which is, I use the word bizarre because I'm not sure what else. It's beyond the judge's authority to do that and to say you can't use the therapist that you're already doing therapy with.
So, Mr. Grassley, are you saying that the trial judge has virtually no discretion?
Oh, of course not.
Because I'll tell you, I've reviewed the record, the text messages. They're shocking.
Absolutely.
They're very shocking. And the number of references in the text messages to frequenting places that sell alcohol, referencing Uber commuting charges or whatever that I believe there's, I don't know what it was called until this record, but I don't know what they call it specifically for incidents where people are drinking and then driving home and being responsible.
Or not wanting to park where he was going, particularly at the beach. That was part of his testimony.
That would be
There's
an
no
explanation.
question that he
But
still socially drinks.
However, so I thought what you were trying to say is, unless the experts say this person has an alcohol problem, definitely has an anger problem. Well, I can tell you, I'm not an expert on that, but just from reading the record, it sounds to me like there is a significant anger problem. But why isn't the trial judge given some discretion to survey the parties, their behavior, their conduct, their demeanor, and the expert testimony to try and put in place some protection to all the parties involved?
Okay, and the judge has some discretion, but what happened here was each of the experts said, this man is not a danger to his child. He loves his child. He is dealing in a positive way and making real progress on his anger issues, and there's no question that those were awful episodes. But
what about the reference to my child is in the garbage or my child needs to be thrown in the garbage?
2 years before any of this happened, and I think that the best inference, I mean, the most reasonable inference is getting into the dissolution case and having no time with his son has been a trigger for my client to deal with those anger issues. And that's what exactly was testified to by the Family Nurturing Center lady whose name I'm drawing a blank on, but who said, this child loves his father and they interact perfectly together and he's always here on time and he always wants more time with his child. And the judge has discretion, certainly, but these are 2-year-old incidents. And none of the experts, including my client's therapist, have recommended either severe in-house or outpatient, inpatient or outpatient treatment for my client for alcohol or for anger, because he's dealing with the anger. And none of them said that he had to stop drinking and abstain from alcohol. Only Judge Cole said that. And when she refused to adopt and approve the party's mediated parenting plan, the wife took the cue. Hey, I can get complete control over my child and don't have to deal with my ex. And so when you read the cross-examination of my client by the wife's counsel, it was focused solely, I mean almost exclusively, on why didn't you just stop drinking? Well, number one, he probably would have been well to say, I enjoy socially drinking. I don't use it as a crutch like I used to. And nobody has ever told me that I had to stop drinking. That's something that you and the judge have come up with. I'm into my rebuttal. The bottom line is that my client deserves a legal consequence of this that allows him to be able to be a parent to his child. And there is no way that, if this stands, he goes to get a modification based on the existing case law out there. Him becoming sober and having conquered his anger issues and have them under control is going to be deemed insufficient. So where does that leave us? A father who loves his child, who's been a hands-on dad since he was born, has absolutely no right to ever parent his child in person or take him to see his parents or take him to a ball game or anything else that a normal relationship would allow. The law cannot condone that as a result under these facts. Thank you, Your Honors.
Your Honors, may it please the Court, Michael Korn of Korn, Zimmer, Jacksonville, on behalf of the appellee. This record has, if not ample, overwhelming substantial competent evidence that supports the trial court's findings as to the best interest of the child, which was ultimately and always the court's concern. Counsel, in his papers and then today during his argument, seems to suggest that this judge, well-respected trial court judge, was somehow acting as a free agent. And that's exactly what trial judges are supposed to do. They're supposed to hear the evidence, consider all the testimony, accept or reject that testimony that they deem appropriate, including expert testimony, which can be rejected, and rule accordingly, because ultimately, under 6113, sub 2, which is the parenting plan statute, the court's main sole focus is the best interests of this child. Counsel says in his papers that there was no evidence of harm to this child. I think Judge Wallace suggested in his question to counsel the question that I would ask, which was when the father erupts over the smallest provocation in the child's presence, how is that not psychological harm?
Let me ask you, Mr. Korn, you just heard Mr. Grossley, and I can only assume it's part of this record that post-mediation, the parties agreed to unsupervised time sharing?
There was a mediated agreement that was apparently put forth to the court, which the court rejected in its order of, I believe it was February of 2021.
So the answer to my question, Mr. Korn, is yes, the parties had agreed on unsupervised time sharing.
For very short periods of time, and then there was, there were obviously markers in that. But, Your Honor, this is the thing. Counsel seems to suggest that the trial court was, in essence, a powerless kind of timekeeper here. In other words, they don't have the opportunity to disagree if the parents want to do something or the experts recommend something. That's not the role of the trial judge. And what the father suggests is that somehow only the trial judge was concerned about the fellow's alcohol consumption, or that it was age. Your Honor asked the question, when were these events? Well, the events of violence, psychological violence, the blowing up, the throwing of things, the punching of holes in the wall, the leaving the child alone when he's 5 months because the dad had to walk out in the neighborhood to cool down, that did occur before the temporary order was entered.
Was that before the agreement to have unsupervised time sharing?
It was, but what's significant, Your Honor, is at trial, which occurred over a 2-day stretch in April of 2021, there was evidence presented of the husband's alcohol consumption and his Uber, as Judge Wallace alluded to, and that went all the way up to December of 2020. So this is not, somehow aged, irrelevant, or somehow no longer dispositive information. Unfortunately...
Wait, you just said April 21 all the way up to December 2020. You're going in reverse.
No, sir, I'm sorry. I may have misspoke. The evidence that was presented at the April 21 hearing carried through to December of 2020. The hearing had originally been scheduled in February and then was carried forward to April of that year. So, but the point I was trying to get at, Judge Wallace, was addressing Judge Jay's question about the timing. Unfortunately, this fellow just has not yet gotten the message. Counsel said something at the end of his argument that I thought was interesting, and this is what was actually addressed during the testimony. When that mediated agreement was rejected by the court, and they ultimately litigated this case, he was asked, well, the court cited this court's opinion in Allen, which, by the way, expressly acknowledged the ability to refer to AA. And when citing to Allen, the husband was asked, well, why didn't you just, stop drinking? And he said, he didn't just say, I should be a social drinker. He said, I don't have a good answer for that. That was what he said. The case, sadly, has been a series of denial. I'm sorry, Your Honor.
And Allen, if I'm right, didn't the party who was ordered to AA have some parental rights, have some visitation?
Let's see. I
I
think before the prior.
What does a judge have to order a parent who has no unsupervised contact with his child, no parental role at all in the child's life, to attend AA and stop drinking? Without a correlation, or as Judge Jay said, without it being tethered to the best interest of the child.
Well, Your Honor, respectfully, I would suggest that the anger, the IED syndrome that this fellow has, and the alcohol are tied. They act one in concert with, and sometimes in amplification of the other. Now, the husband says, I only drank because it was a coping mechanism because I was unhappy during the marriage. In actuality, his drinking went well before this marriage. He had a DUI in Missouri. He said he wasn't stopped correctly. He wasn't convicted.
Wasn't convicted for that. You can't say he had a DUI.
He was arrested for a DUI, Your Honor.
That's a big
All I'm saying is this wasn't a situation where this fellow starts drinking at the point in time that he meets my client or they get married. All of the experts did say one thing, that his anger problems were of long-standing duration, and they were deep-seated. They were ingrained in him. This is not something that his chosen therapist, Ms. McQueen, who saw him, for under an hour every few weeks, could deal with. In fact, McQueen specifically acknowledged she had no expertise in IED, didn't know what would be the appropriate methods, and when asked, well, what if the child just did something innocently that set the dad off? What would the outcome be? She said, well, I would hope that these coping skills that we're talking about would be sufficient. Respectfully, I would say that misplaced hope is not designed to be in the best interest of the child. And that's ultimately, I think, what the focus is. Now,
Mr. Corn, you're a great lawyer. We have two great lawyers today and a smart man. I have not heard your answer to Judge Harris's question, though. Where is the connection between what she prohibited, no alcohol in AA, and this child? I just don't see the connection.
but, Your Honor, when the parties were together, he would leave the home, he would go to local restaurants in the area of their residence, he would drink, he would come home intoxicated, he would drive sometimes intoxicated.
But what about Judge Harris's point, which is an excellent one? There is Family Nurturing Center time sharing, meaning supervised time sharing and Zoom interactions, and no parental rights to speak of. So what would it matter if he wanted to drink on his own time? I'm just having trouble closing the circle.
Where I think the court believed the drinking and the anger management fell together was that, as I said a moment ago, that they work in concert with each other. And until the father had a true recognition of both of these problems and had an opportunity to fix them, there was still the risk to the child, and that was the ultimate concern of this trial judge. So can we sit here and say, this incident was sparked because he threw a pan while he was drinking? The record doesn't say that, but I think it is somewhat unrealistic to think that drinking and anger were unrelated. In fact, he specifically said that he used the drinking as a coping mechanism.
And thank you for that answer, Mr. Corn. But what about Mr. Gressley's point? Let's say your client, or his client, stopped drinking tomorrow. No more anger issues. He files a petition to modify.
Right.
And isn't he painted in the corner of what he described of not being able to turn this over? And so he's basically has to live with this the next 15 years of this child's life?
I would suggest that may be a somewhat unrealistic and extreme view of some of the cases, primarily out of the First District, Bell being one of them. I think Janato was another one that was referenced. Your Honor, if I might.
You may.
Thank you. But, so the point that Your Honor is raising is, and it's really kind of an interesting, almost philosophical point, that courts throughout this state have been wrestling with, which is, what is a reasonably contemplated occurrence for purposes of modification, and what is unanticipated? So in this context, this is not a situation like in some of the cases that we briefed that the child moves from preschool to kindergarten, or a situation where a parent is on military assignment and is rotating home, where we can reasonably anticipate that we know in X date they're coming stateside. We can't say with certainty that it's reasonably contemplated under these circumstances that the father will succeed in his effort to address his anger and deal with his alcohol issues. Now, we hope he does. But
If he does, is that a good enough thing?
well, if you look at the Daniello case, which which we cite in our answer brief, and it's a Fourth District case from about a year ago, And interesting, they cite a First District case to this very point, and I think, Judge, this is the dilemma that courts have been wrestling with, this idea of what constitutes a substantial change in circumstances, and then the key word is, again, this unanticipated or not reasonably contemplated prong. And so in Daniello, the court cited to Bell, the case from the first, and they said that the circuit court's order that amended the agreed final judgment was reversed, and here's the text, without prejudice to the mother's right to seek modification attributable to a substantial and material change or other legally available reason. Okay, and then this is, I think, the more significant thing. They cite to a case called Chamberlain versus Eisinger. Again, this is all in the papers. The burden is on the parent seeking modification, but that should not preclude legitimate review in the best interests of the child, where there have been significant changes affecting the well-being of the child, especially when the change of circumstances had occurred over a substantial period of time, quoting Peterson, P-E-D-E-R-S-E-N, which is a First District case, 752 Southern 2nd, 89. So, can I tell the court that there is a neat box that this issue can be placed into? Because you have the kind of, I say, disparate line of cases like Bell and Janata that are out there. But you also have recognition like in Daniello.
And those cases, and I'm familiar with those.
Yes, I figured you would be, Your Honor.
I used to be there, as you know, Mr. Korn. They would militate against a petition for modification, if it happened just as I'm describing it, correct?
Well, I suppose it might, but the irony, of course, is if this court were to affirm, the Judge Cole's order becomes the law of the case, and it would be hard-pressed for the mother to come back and say, oh, you can't seek modification because it's not a substantial, unanticipated change or not reasonably contemplated. So I think that an affirmance actually would put...
Explain that again. I missed that.
Okay. So the court, in its original partial final judgment and in the order denying the father's motion for rehearing, said that of course he can seek modification if he can show that there has been substantial improvement towards the best interest of the child. So if this court, for instance, were to affirm, and so at some point down the road, the father is able to show, by filing a petition for modification, that he has in fact reached some recognition that his IED is under control. And the judge didn't expect perfection, by the way. The order said on the anger issues that the goal of all of these steps were to eliminate or substantially reduce. And I think that's significant because Judge Cole is being painted as some, inflexible, you've got to do everything just so. The fact that, people are people and they're going to make mistakes sometimes. But the question is, did this judge abuse her discretion in the face of this substantial competent evidence? So back to the question that you asked me to clarify. If the case is affirmed and the husband is able at some point to make the appropriate showing, I think if the wife were to come back and say, oh no, Bell says you can't show that this was an unanticipated occurrence, if I would suspect the trial judge would say, this is the law of the case. The order says, of course you can seek modification. Counsel, poo-poos that a little bit, saying, that's not right. But I think given the flux in the law, this idea that he's been somehow given, this life sentence of no role in the child's life is not what Judge Cole intended. It was not a misapprehension of the law, I don't believe either. Again, as I started, the ultimate focus of all of these issues is what's the best interest of the child? Is it in the best interest of the child for dad to not recognize that maybe he needs to get some control over his alcohol consumption?
Well, let me ask you about that.
Yes, sir.
Again, it goes back to the question I asked to begin with the ban on consumption of alcohol and the requirement to attend AA. If that has nothing to do with the best interest of the child, did the judge abuse her discretion in ordering it?
Well, Your Honor, I would respectfully submit that it does have a direct
Let me tell you
bearing
what
on
she put
it.
in that paragraph. The goal of this is to support the husband in his efforts to refrain from alcohol. Well, the best interests of the husband have nothing to do with it. And she says that's the goal of putting that in there.
But Your Honor,
What happened with the kid?
the unstated part of that, why is that in the best interest of the husband? It's in the best interest of the husband because it will ultimately reduce potential risks to this child, and that is in the best interest of the child.
She didn't say that, Mr. Corn. Does she?
I think it, Your Honor,
I missed that if she did.
respectfully, it is implicit in the court's consideration of this entire case. The fact that this child was witness to violence, psychological violence against the nanny, plates being thrown, things of that nature, it is implicit. I don't think we have to use a crystal ball to think that, that the alcohol usage didn't have some bearing and contributing factor to the anger. Now, the anger, in some measures, Judge Harris, was considered by some of the folks who testified even more significant than the alcohol.
Look, there's no dispute that there's significant anger issues involved here. I mean, you haven't even talked about the abuse to the pet.
I was getting there. One of the IED symptoms is violence against property and animals.
I understand, but my question again is how a parent who has no parental rights, no unsupervised contact with his child, how can that parent be ordered to go to AA or not consume alcohol or do anything without a direct correlation to the best interests of the child? He's not seen the child. If he had visitation, that's one thing. If he got to make decisions concerning the child's best interests, maybe that's something else. But he has no contact with this child.
Well, he does have
No unsupervised contact.
He has structured contact, and the fact that he did not drink when he went to the nurturing center to visit, that's good. Obviously, that's good. But I'll return to the response that I gave previously, and I think it's the best one because I think it's the only rational one, which is we're looking at this in a continuum. It's not just what alcoholic beverages does he consume and where and when and to what degree. And it's not just the IED, which has been long-standing, decades. Even his parents couldn't deal with him. It's not each of those taken in some clinical, structured tube. They are all interrelated. The fact that even the husband said, I drank because it was a coping mechanism for me. The fact that the court didn't complete the sentence by saying that the interrelationship between his alcohol consumption and his anger has a direct bearing on the child's psychological health, if for nothing else, doesn't mean that it's not there. It doesn't mean that there is not substantial competent evidence in this record that supports what this court did. So for those reasons, I would suggest that affirmance is appropriate, but it is not affirmance forever. I really
I'll ask you one more question.
Yes,
We
sir.
haven't really got to yet on the shared parental responsibility. Where's the correlation between his anger or his drinking and the rights of a parent to decide what school his child goes to, for example?
I think until it was the court's view that until the husband had some better realization of what he needed to do, that the best interests of the child were furthered by the mother exercising that responsibility for this period of time. Now, the father was not totally cut off. She was required to, and kept him informed about everything involving this child. And in fact, in the order on rehearing, Judge Cole specifically says, and if she does not do this, then I expect to see a motion for enforcement. So, the father, yes, was he having supervised visitation? Yes. Was there a good reason for it? Absolutely. Is it
We're
support?
talking about visitation. We're talking about the ability to make decisions about.
No, but I'm saying is, to that point, until he can get some self-realization about the harm that he could cause this child, it was appropriate and not abuse of discretion.
Seems like it's intended to coerce him to stop drinking because that's what the judge wants him to do, without it necessarily relating to the best interest. The child's best interests are protected. There's a supervised structure set up. Mom's making all the decisions. The child's protected. It seems like this judge is either being punitive or coercive.
I'm into red light, but I'll just say the court specifically said that it was not attempting to be coercive at all. The purpose was to try to help this family. For those reasons, Your Honor, we respectfully submit affirmance is appropriate. Thank you.
Got a little over 2 minutes, Mr. Grassley.
Yes, thank you. Judges, of course, can accept or reject expert testimony, but what happened here was beyond the pale, because there was no reason for it. Dr. Blackman explained what the best interest of a child was, this child. It's the same as what the Florida statute said, which is to have as much contact with each parent as possible. Dr. Blackman and Dr. Jackson and my client's therapist all agreed that this man loved his child. The thing that has been overlooked is that it takes two to have a relationship. My client never testified that he drank because of his marriage. He had anger issues from the time he was young, and he's learning to deal with them. And the uncontradicted evidence in this record is that he's made great progress. There is no correlation with the alcohol use. Judge Cole decided that she knew better than everybody else, and I'm not accusing her of being rigid or trying to phone it in or something like that. What I'm saying is she overstepped her bounds. She's made a correlation between his drinking and his anger issues that have turned this into something that is, as Judge Harris has been asking, there is no correlation. The wife battered my client at one point. So my client, I can't justify any of his outbursts or the things that he said, but none of them, seeing your parent angry like that, that's a terrible thing. But the actual truth is what happened at trial, what was the testimony at trial, was that he was making great strides in that and learning how to know when this is happening. The drinking had nothing to do with this. Even Ms. Fulgram, who, when you look at Dr. Blackman's report, she didn't testify. She was a counselor for both of the parties, but it turns out she's a pastoral counselor, and they did this through their church. But she called my client an abusive alcoholic, and right after she said that, she said, but his main issue is his anger without the alcohol. That's the big problem. Learned behaviors can be unlearned, and that's why we have therapy. But if you are going to affirm this, the real issue is how much built-in flexibility can we build into an initial parenting plan? Because this judge explicitly said, I don't have the authority to do that. You have to come back to court every time you want to change something. Well, this case presents a perfect example of what needs to happen, which is my client needs to have the ability to do unsupervised, and no, we're not delegating authority to anybody else, that the court can retain jurisdiction to revisit that. And the judge misunderstood the law on two levels, and I've pointed it out in my briefing here. Thank you.
Thank you. Thank you, counsel, and we are adjourned.